legal malpractice in the context of withholding client monies. Good afternoon. I'm Neil Burns. I'm an attorney here at my office at 6 Beacon Street. We represent victims of legal malpractice in Massachusetts. Along with my partner, Roshan Jain, we've represented hundreds of people who have been victims of legal malpractice. We have an article in our website that talks about an attorney getting suspended from practice because he actually took a client's monies. Let me explain how this works so you have it in context, because sometimes people think that attorneys are doing something wrong when they're not. When you settle a case, for example, a personal injury case, or you have a client's monies, for example, in a real estate transaction, you put the monies in IOLTA account, IOLTA, interest on lawyers' trust accounts. That's money that's joint money. It's client money and it's lawyer money. Maybe it's two different clients' money combined together. The lawyer then divides it up. The lawyer sends the client their share, and any other people their shares, other lawyers, other people that are entitled to monies from the settlement of a case or the resolution of a real estate matter, and the lawyer takes a fee. In the case at issue, the lawyer took his fee, and the client was out of the country at the moment, came back, and the lawyer said, look, I've got a problem, a personal problem. I used some of your money, but don't worry, it'll be just a matter of weeks. And in fact, in a matter of weeks, he did get the money to the client. This isn't allowed. In fact, again, the attorney got suspended. You can't take your client's money. It's sacrosanct. You have to let that money stay in that IOLTA account and give it to the client. It can't go any other route. It's not allowed to go a circuitous route to your father, to your mother, to pay off your mortgage, and then come back to your client later on when your cash flow is better. That money is the client's money. That's why this attorney got suspended. But that doesn't happen that often. It happens in that instance, but many times it happens in another way, another context. Attorneys get a settlement check and they don't tell the client. Attorneys don't give the client their fair share. They take a larger percentage than they're supposed to. They withhold monies that they don't tell the client why they're withholding it, or they pay money to a third party, as I mentioned earlier, but they don't tell the client who, what, and why. It could be their brother-in-law. It could be a legitimate lien. But the client is entitled to know where every penny of his or her money went out of that settlement, out of that real estate transaction, out of that divorce, whatever it is. If you've been a victim of legal malpractice, call Burns and Jain. If you suspect your lawyer took money, settled a case without talking to you, if there's money in his or her client's account that should be yours, give us a call. We've handled many legal malpractice cases. Again, most times we get calls, there's really not something we can do. But many times, the attorney has stolen money, misappropriated money, acted in conflict of interest, blown the rights that you have as a client, and there's a case for negligence there. So if you have a question, call us. It's a free initial consultation. Call Burns and Jain, 617-227-7423. Thank you.